Hi, my name is Damian, and today I'll be explaining what customary international law is and discuss its importance as part of my public international law assignment. Hope you enjoy. Vulcan Low, in his book, mentioned that the purpose of all norms of law is to incorporate an element of predictability into the behavior of other people. This is the ultimate purpose of all legal institutions, to have the ability to function on the assumption that other people would act in accordance with the law. Judge Greenwood defined the word customs as unwritten law or rules that has evolved over a period of time. Custom, unlike treaties that are binding on state parties only, is that source of international law which generates rules binding on all states. Article 38 Clause 1b of the Statute of International Court of Justice refers to international custom as evidence of general practice accepted as law. It is remarkable how many fundamental issues about international organizations' status in the international law system remain unresolved and contentious given how long and significant they have existed. One of these concerns is whether or not international institutions may directly influence the development of customary international law. Historically, state practice and opinio juris, or the opinions on what international law authorizes, mandates, forbids, have been seen as the sources of customary international law. By influencing what states do and think, international organizations undoubtedly contribute indirectly to customary international law. International organizations also offer platforms where governments can discuss their activities and stake out views on the nature and status of customary law standards. Resolutions of the United Nations General Assembly, UNGA, for instance, are occasionally cited as proof of a principle of customary international law. The ICJ found in the Continental Shelf case that the essence of customary international law must be looked for in the actual practice and opinio juris of states. Both of these factors listed must be present in order to create a new rule. State practice refers to the actions taken by the state when performing its executive, legislative, judicial, or other duties. The relevant practice of states is not confined to actions taken in relation to other states or problems of international law. Actions taken within the state, such as domestic court rulings, national legislation, and how a state treats its own citizens, may also be relevant. State practices take various forms, including but not restricted to diplomatic acts and correspondence, conduct in connection with resolutions adopted by an international organization, conduct in connection with treaties, executive conduct, legislative acts, and decisions of national courts. In the North Sea Continental Shelf case, the ICJ indicated that the most important practice is that of states whose interests are specially affected. State conduct alone is insufficient. It must also be demonstrated that people believe it to be enforceable as law. This conviction by states in the compulsory nature of this activity is known as opinio juris, sive necessitatis, opinion that an act is necessary by rule of law. There must be some standards by which we can separate state behavior that amounts to law from other types of state activity, such as courtesies of act or acts of kindness. In the Lotus case, the Permanent Court of International Justice, PCIJ, acknowledged opinio juris as a crucial component of the development of customs. Even if it is challenging, determining opinio juris is possible. A direct or more frequently tacit approval of this practice as law by the interested states suffices to establish the opinio juris. The most direct indication of a state's legal conviction is that express of proclamation that is a particular regulation is required. As has been demonstrated, state practice and opinio juris have long been regarded as the acknowledged sources of customary international law. But over the past several decades, there has been a determined effort in legal research to reinterpret these sources and move away from a strict reliance on them. At its most extreme, this scholarship contends that international treaties, particularly those encompassing human rights obligations, actually generate international legal norms because such conventions are inevitably more than just the codification of pre-existing legal norms. Rather, they also result in the creation of new ones. This scholarship has provided a framework that aims to change the role of long-standing state practice and opinion juris in the process of turning conventional or treaty-based international law, binding only on the state signatories, into customary international law, at times relying on judgments from International Court of Justice, which is binding on all states. This unconventional body of literature proposes a framework that maintains the signing of a convention or treaty by a large number of nations is sufficient to prove that a new customary legal norms have been created. Despite the fact that this unconventional scholarship finally succeeded in redefining the origins of customary international law, it was not without criticism. The second part of this question seeks for a discussion on the importance of customary international laws. If a dispute involves two parties who are not bound by any treaties, or if one of the parties is not a party of any applicable treaties, the court must solely depend on customary international law to resolve the dispute. First off, customary international law sometimes has more judicial authority than treaty law. As opposed to treaties, which solely bind the parties thereof, once a norm becomes customary international law, it applies to all states, even those that are new to a particular rule or activity, provided that they did not strongly object during the norm's development. Second, it might be assumed that the articulation of legal responsibilities is more precise and clearer under treaty law, but this is not always the case, since they developed in response to specific situations and cases are frequently stated in the written decisions of international courts and tribunals. Customary laws may offer better accuracy in particular situations. On the other hand, it has been asserted that international customary law is of essential importance to the unity of international law. There aren't many often conflicts between distinct customary rules because of how it develops. Furthermore, it is generally acknowledged that customary international law is of general application, valid for all states, as opposed to being specific. In other words, under customary international law, all governments are subject to the same duties, as it puts all states on an equal normative footing, unlike treaty law. This gives the system of customary international law an underlying normative coherence. This characteristic of customary international law has been recognized, at least in part, as a crucial centripetal force within the framework of international law. Customary international law is also important in regards to conflicts on humanitarian law. Customary international humanitarian law, which is a subset of customary law and is frequently referred to as the law of war, is a set of uncodified public international law principles that regulate the conduct and legitimacy of armed conflicts. There are numerous international humanitarian law treaties that have been universally ratified and are binding on all parties, such as the Geneva Conventions, but not all of these treaties have been ratified by all nation states. Therefore, these laws will only be binding on the member states that have chosen to abide by them. This gap is filled by customary international humanitarian law, and even states that have not ratified by humanitarian treaties are obligated to adhere to them during an event or armed conflict. That is all from me. I hope you enjoyed this time of me explaining what customary international law is. Thank you for watching.